Welcome to today's webinar, Empower Hour, Legal Rights and Resources for Caregivers. More than 40 million Americans serve as family caregivers, and often they are unaware of the services and resources available to support them. Today, we're going to be talking about the legal rights of caregivers to take time off of work, avoid discrimination, and to learn about other caregiver resources available. This presentation is intended to give general information and is not intended as legal advice. There will be time for Q&A after the presentation. One last thing, I also want to say that I hope to be able to answer your questions, but there may be instances I might have to tell you I don't know it, either because it's not information I have offhand or it might be too specific for today. However, I encourage you to fill out an intake with us so that we can properly research the information. I wanted to let you know that the topic of caregivers is just one area that the CLRC speaks about. We have a cutting edge webinar series supported by a grant from the Tower Cancer Research Foundation and a grant from CGen. This webinar is part of the series and it is called Empower Hour, because the pandemic made things more difficult for everyone, especially challenging for someone affected by cancer. Now, since the pandemic, the CLRC is here for you before the pandemic and after to be providing free legal resources, including this webinar series, to let you know about important information and important resources to help. The previous webinars listed on this page are available at the CLRC's YouTube page, and this one will also be available. So you can listen closely. You don't have to worry about taking notes. If there's a part of the presentation you'd like to listen again, you can listen anytime after this recording on the CLRC's YouTube page. The CLRC stands for the Cancer Legal Resource Center. We are a program of the Disability Rights Legal Center, and that's a 501c3 nonprofit. The CLRC provides information and resources to people affected by cancer, including patients, survivors, caregivers, and healthcare professionals. Our resources are free, regardless of income. If you would like to view our resources on any number of topics related to cancer, please visit our website. Educational webinars like this one are recorded, as I mentioned, so we can later put them on YouTube, on our YouTube channel for you to share them with anyone who may want to learn more about a variety of topics. If you have questions about today's presentation, please type them in the chat box. You can type them anytime during this presentation. However, I will be addressing them at the end. I will be leaving time at the end of the webinar to answer some questions. I want to be clear that that part of the presentation will not be recorded. However, if you have questions about your specific situation or someone you know has a question you want to ask about, please fill out our online intake form at clrcintake.org. As you can see on your next screen, after you do so, we can research laws and resources for you and provide you with free customized resources. Everything is confidential. And actually, our clrcintake.org is in the slide after this one. So stay tuned. We generally do not provide direct representation or give specific legal advice. We focus more on the educational model in order to empower individuals with knowledge of their rights under the law and give referrals to other legal resources when necessary. We have people on staff who speak English and Spanish, and of course, we keep all information confidential. And as I said, I'm going to do my best to leave time for questions at the end of the webinar. And we certainly encourage you to reach out. We also have our free toll-free assistance line. So you don't have to fill out an online intake and call our 800 number or 866 number. Instead, you can just do one or the other. We will get back to you. So if you have questions about your specific situation, someone you know has a question you want to ask about, fill out our online intake form. It's on your screen for free, customized resources so we can research laws and resources for you. Again, everything is confidential. So people often ask, what does cancer have to do with the law? This is a list of some cancer-related legal issues. Cancer affects the patient, survivor, families, healthcare professionals, and impacts many different areas of the law. If someone has a legal question and is affected by cancer, whether or not the topic is listed here, they can contact the CLRC for more information. The CLRC also has a professional panel, which includes attorneys from across the country who help those with cancer if a caller needs help with a matter in their state and practice area. So you saw on the previous slide the practice areas that attorneys handle, but just to recap some of them: landlord-tenant, health insurance matters, medical malpractice, estate planning, employment law, and divorce law. If you are a lawyer anywhere in the United States, we encourage you to apply. It's a minimal commitment. All the attorney agrees to is a half-hour consultation. It's very easy to apply. There is no fee to submit an application. We would really love if you are a lawyer or know a lawyer that wants to give back, to encourage them to learn more about a professional panel. With the generous support of the American Cancer Society and Breakaway from Cancer, the CLRC has a revised version of the Patient Legal Handbook. The handbook provides an introduction to our most common legal issues that a patient diagnosed with cancer is likely to face. It is available to download for free online in English and in Spanish by going to our website, theclrc.org. Providers, meaning doctors, can request printed copies shipped to their offices. And the CLRC also maintains a library of fact sheets on a variety of cancer-related legal issues on our website, including, of course, the Patient Legal Handbook. And the handbook really does provide an overview of the most common issues that people living with cancer and their families face. So we highly encourage you to check out our Patient Legal Handbook, or, of course, to order a bulk order for your office. We ship that out for free. So I just want to do a quick overview of the topics that we'll be discussing today. Let's dive in. You can see on your screen: caregiver duty, workplace protections, time off, planning ahead, benefit programs for caregivers, finding caregiver help, and caregiving resources. So by the end of this hour, and we'll make sure to wrap everything up within the hour and even leave some time for questions, hopefully, you will become a lot more knowledgeable about these issues that you see on your screen. So that's why we call it the Empower Hour. You will be empowered with so much helpful information. So some major metropolitan hospitals may still not allow caregivers at this time. We encourage that since the COVID-19 pandemic, initially there were more restrictions, then hospitals or doctors' offices lifted those restrictions. We highly encourage you, even if there have been restrictions in place in the past, we encourage you to check. Those restrictions might be lifted for caregivers to attend appointments. And it's important to note, if caregivers have been allowed, it can also change in the future. So it is important to maintain that contact with the healthcare facility. Things can change. They might be letting you know in advance, but they might also not be. So if you would like a caregiver to come with you to an appointment, it's a good idea to check. And if you show up with that caregiver and something has changed, then you can already discuss kind of a backup plan with that caregiver. Maybe that caregiver will not be able to be in the room with you, but they might be able to listen in. The provider, the doctor may allow them to be on the phone. You can call them on your phone and they can listen, ask questions, take notes. Also, another way to consider, if you have a cell phone that allows for video capability, if the doctor permits, you can have that person on video. They can listen, look at the doctor can see them as well. They can take notes and ask questions. So as we get started, I wanted to make a key distinction, and I'd like to get that right off the bat. Today's discussion when it comes to legal resources is mostly going to be about how federal laws protect cancer patients, survivors, and caregivers. Keep in mind that all of these laws are just a baseline. As we'll discuss, state laws vary greatly from state to state. You may also be entitled to more protections in various contexts, including through state and local laws, employee manuals, contracts, and insurance plans. So tip number one, know your duty. There is generally no legal requirement to become a caregiver. regardless of whether the person who is ill is a family member or close friend. A person can take on responsibility for a patient's health, which can then create a duty of care. When a caregiver has taken on a duty to care for another person, and the extent of the duty will depend on each situation. So you generally have don't have to be someone's caregiver. You do not, but once you begin to act like a caregiver, you do have a duty to do so responsibly. A parent has a duty to take care of their minor children. A parent's duty to take care of their child ends when the child reaches the age of majority, usually age 18 in their state. However, many states have laws that require a parent to continue their parental care if the child has a disability that causes him or her to be unable to take care of themselves. For instance, in California, and I just give California as an example, the Code 3910 states in Section A, the father and mother have an equal responsibility to maintain, to the extent of their ability, a child of whatever age who is incapacitated from earning a living and without sufficient means. Adult children do not have a legal duty to care for their parents, despite cultural traditions to do so. However, many states have what's called filial responsibility laws that require adult children to financially support an aging parent in need of financial or general support, or to potentially reimburse the state for services used by the aging parent. For example, in California, Code 4400 states, except as otherwise provided by law, an adult child shall, to the extent of his or her ability, support a parent who is in need and unable to maintain himself or herself by work. For questions about filial responsibility laws in your state, please contact the CLRC. Look, we're already on tip number 2. Workplace protections exist for caregivers. We're going to discuss some protections in the workplace. It's important to check individual state laws and services, which may provide additional coverage or benefits. Remember, the federal law is just a baseline. The American with Disabilities Act, or ADA, is a federal anti-discrimination law that protects people with disabilities, and in some cases, caregivers. Many people with cancer do not consider themselves disabled. It is important to note that the definition of disability is different in various legal contexts. Often, regardless of how a person chooses to affiliate themselves, it's important to start with the definition of disability to see if a disability law offers protections or benefits to a person living with cancer, and then look to see if any protections apply to caregivers. As we all know, a person's abilities are constantly changing with a cancer diagnosis. Therefore, it may be necessary to reassess eligibility for programs and laws if a patient's or survivor's abilities change. As we talk about these laws in the context of caregiving, it is also important to think about how these laws can serve the caregiver and the person with cancer who has the caregiver to help them. As you may have experienced, when a person is sick, it is extremely helpful to have someone advocate on your behalf. Just to briefly go over the 3 parts to the ADA's definition of disability. Number 1, the person has an impairment. Number 2, the impairment limits a major life activity. And number 3, that the limitation is substantial. If important parts of a person's life are affected by their cancer diagnosis, they may be eligible for ADA's protections against discrimination for both their caregiver and themselves. So, major life activities are broad for the purpose of the ADA. They include walking, talking, breathing, eating, caring for yourself, and the particularly broad activities of daily living. A substantial limitation is an inability to perform a major life activity in the way that the person in society normally would be able to perform it. Cancer can be a disability under the ADA, but it is determined on a case-by-case basis. It's not just the cancer illness itself that is considered, but also the side effects of the treatment. Remember that some state anti-discrimination laws may specifically list cancer as a disability. One example of such a state is in California, or they may have a lower standard than a substantial limitation. Here's how the ADA applies to caregivers. The American with Disabilities Act, or ADA, prohibits private employers with 15 or more employees from excluding or denying equal jobs or benefits because of a relationship or association with an individual who has a disability, which, as we discussed, can include cancer or the effects of cancer. Remember that many states have their own anti-discrimination laws that say that the employer with fewer than 15 employers can, or rather is required to follow this law. For example, as little as 1 or 2 employees in a company, the ADA is just a federal baseline. Caregivers should therefore not be treated differently or have their employment terminated by an employer based on knowledge that the caregiver has a quote association with end quote a person with a disability. Here's an example. An employer who assumes that a caregiver won't be able to handle their normal workload or gets passed over for a promotion because the employer knows that they're caring for a person who is sick. Familial caregiver discrimination is also protected under the Genetic Information Non-Discrimination Act, or GINA, since employers can't discriminate based on family medical history. Although caregivers are protected against job discrimination due to their associations with a person with cancer, they are not entitled to reasonable accommodations, such as a reduction of work hours or changes of the workplace. By the way, this is different from a person with a disability who may be eligible for accommodations. If an employee's work performance drops due to caregiving responsibilities, employers can make employment decisions based on performance to terminate employment. But if an employee is performing their job adequately and an employer learns about their caregiving responsibilities and treats them differently, the employer may be discriminating under the ADA. Now we're going to discuss another federal law, commonly known as FMLA. That stands for Family and Medical Leave Act. It allows qualified employees to take up to 12 weeks of unpaid leave, and that's at once or in shorter blocks of days or even a few hours within a 12-month period. The law applies to patients and caregivers of a spouse, child, or parent with a serious medical condition. The caregiver and/or patient is often required to get medical certification from a healthcare professional stating that the caregiver's services are needed. A person is allowed to take FMLA time off work to care for themselves or a covered family member. People that qualify for covered family member are parents or a person acting as a parent, minor children or adult children who are incapable of self-care because of a mental or physical disability, and spouses. As long as the person is a covered family member, a caregiver can take time off work under FMLA to care for them. The law unfortunately does not allow caregivers to take time off to care for their siblings. Not all employers are covered by the federal law. Local, state government, and federal employers are subject to FMLA, and private employers if they have 50 or more employees within a 75-mile radius. Remember that some similar state laws may exist that could provide you with additional protections. Employees at these companies that I just described must have worked at least 1,250 hours in the past 12 months and must have worked for the employer for at least a total of 12 months in the last 7 years. The 12-month requirement doesn't need to have been all at once if someone is a seasonal worker. For example, and 1,250 hours averages to about 24 hours a week. If someone is going to take FMLA leave, it is important to talk to their employer about going on leave. The employee will likely have to provide a medical certification. In a caregiving situation, the caregiver will need to provide medical certification about the person who needs the caregiving. They may also need to include information that is different from what the patient would have to do. the Department of Labor has a separate form for family members. Employers must comply with all applicable laws regarding the confidentiality of medical information. Therefore, the employer must keep the employee's medical information and/or records separate from their personnel files in order to protect their privacy. Here's a general tip. If you ask a general practitioner to complete a medical certification, their letterhead will not say oncology, and you can avoid disclosing the nature of the illness to an employer if you don't wish for them to know. The next definition I'd like to get into is the 12-week period of job and health benefit protected leave under the FMLA. Those 12 weeks of leave can be taken all at once in a 12-week block of time or in intervals, such as 1 week per month for chemotherapy or every third Friday off for a doctor's appointment. You may use intermittent leave only when it is medically necessary. The employee must provide a certification by a healthcare provider if the employer requests it. A medical certification would state that working on this different schedule or being able to take leave on an intermittent basis is necessary to provide for treatment or to provide care or provide psychological comfort to a family member with a serious health condition. Employers have to calculate FMLA leave using an increment of time that's no larger than how the employer would use to account for use of other forms of leave. So, for example, if an employer calculates leave in blocks of 3-hour shifts, missing most of one shift will count as missing 3 full hours, but may not count as missing a full day of work. It's important to know that the FMLA can work alongside with the American with Disabilities Act for patients. We just talked about American with Disabilities Act, so hopefully it's more familiar. For example, if a patient with ovarian cancer took 12 weeks of FMLA leave but was not ready to return to work, additional leave may be granted as a reasonable accommodation under the ADA, especially if a definite end to the leave is clear. However, taking more time off of work is not always considered reasonable and is decided on a case-by-case basis. Unfortunately, because caregivers are not eligible for reasonable accommodations under the ADA, a caregiver could look to their employer's policies or handbook for additional protections or maybe state laws. FMLA is unpaid. Certain states have paid family leave, so it is important to check with your local government agency to see whether it is an option in your state. The states that do have the program provide partial wage replacement during leave for a limited period of time. These state laws often work in conjunction with the FMLA. It is important to note that being entitled to paid family leave does not necessarily mean you're entitled to FMLA leave, and some paid family leave programs allow income replacement to take care of family members other than just a parent, spouse, or a child. And here you can see some additional programs that will begin at a later date. And here's a map of the country and programs that are in effect, and then programs that will be beginning. Tip number 3, we're making great progress. Have difficult conversations early and have loved ones document their wishes. Having difficult conversations early is important so that the patient can create valid legal documents while he or she has the ability to understand and make informed decisions. Now, of course, these are difficult conversations, no matter what someone's health is. Unfortunately, the longer someone waits while an illness progresses, the greater the likelihood that these documents may be called into question. People must have the mental capacity to create these documents for them to be valid. It is also essential that you allow the patient or the person with cancer to make their own decisions. It is important to discuss these issues with the person with cancer. If a caregiver is pressuring a person with cancer to make healthcare and financial decisions, documents can also be called into question for fear of undue influence, pressuring the person to make a decision that they did not actually wish to make. It's a good tip to check to make sure existing documents are up to date, that they follow current state laws, all assets are covered, and the correct beneficiaries are named. It can be helpful to talk to an attorney to avoid common mistakes which could result in making the documents invalid, and to avoid questions of undue influence. Advanced healthcare directives are written instructions that state a person's wishes about medical care and treatment they want to receive if they are unable to make medical decisions for themselves. These include types of treatment that should or should not be used. Advanced healthcare directives are intended to avoid unwanted care, reduce suffering, and to ensure that a person's wishes are honored at the end of their life. A hospital visitation directive states the people who may or may not visit in the hospital. If advanced directives seem overwhelming to you, you may wish to look at something called the 5 wishes. 5 wishes are helpful to fill out on your own, along with providing them to the person you are caring for. This will give you an idea about what questions are helpful to ask and some insight into which questions are harder than others to answer. While it is always best to ensure that you have an attorney look over any legal documents, that is simply not possible for everyone. The 5 wishes meets the legal requirements for an advanced directive in 42 U.S. states and the District of Columbia. In the other 8 states, your completed 5 wishes can be attached to your state's required form. It does cost $5 to request an actual form, but it asks some great questions and gives good suggestions about what someone might want their advanced care to look like. Caringinfo.org, that's the other website on your screen, is also another great option because they have advanced directive forms with extensive instructions that make filling them out as clear as possible. Many hospitals also have their own advanced directive forms and free notary services. Power of attorney for healthcare, depending on what your state calls it, names someone such as a relative, friend, or someone else who you trust to make medical decisions for you when you are not able. And I just want to say one thing, that we have an entire presentation just devoted to advanced planning because there is so much information to cover. It literally necessitates an entire presentation on its own. So if you're interested in this topic, we encourage you to check out our webinars. And there is an advanced planning webinar. It's really interesting and really helps break down some differences between different options and how they can be useful. But I want to make the note just before we continue, which is that it can be a very difficult topic to discuss, whether it's for yourself or with someone you care about. But what I always try to emphasize when it is relating to advanced planning, especially if it's a will or a trust, that it enables someone's wishes to live on beyond them. No one lives forever, even Betty White. So it's important to recognize that there is a way for someone's wishes to live beyond their own lifespan and to have things happen as they would want to, whether they were still here to make those decisions. And that is with advanced planning. And if a person chooses to not make a will or a trust, that's fine. But it's important to recognize that if they don't have a will, their state will provide them with a will. The state already has that plan in place if the person does not come up with their own. So I ask each and every one of you, who is better at knowing what you would want, the state or you? So it's a good idea to think about it, just to learn about it, even if you're deciding to not handle that at that moment, but just to become more informed so you know how to best ensure that your wishes are in place. And you can always change them if your circumstances change. If you win the lottery, you have a lot more to distribute. But even if you don't have many assets, it is a good idea to account for them. It makes everything easier no matter what, and it makes sure that your wishes are in place. So let's continue. A power of attorney deals with all medical decisions unless you decide to limit it. You can also give specific instructions about treatments you want or don't want, or about other issues that concern you. It is important to consider who is named as the power of attorney for healthcare. Ideally, they should be trustworthy, share the same values, and someone you've talked to about what the end of your life wishes are. Sometimes a close family member is the best option, but sometimes it is too difficult. So people select others that may have an easier time making hard decisions. Power of attorney for financial affairs. A power of attorney for financial affairs allows a patient to name another person to handle financial matters for them, including paying bills, signing and depositing checks, and accessing bank accounts. A power of attorney for financial affairs is a legally binding document that a person prepares or has prepared for them to sign, where they choose a trusted person known as their agent to act for them if they become incapacitated or unable to act or speak on their own behalf. Whether or not someone is incapacitated, this is a common concern. Who gets to say that I'm incapacitated? What if the person I name wants to say that I'm incapacitated? That's not true. It is only determined by a doctor or judge. It's not determined by you. It's not determined by your friend. It's not determined by the person that you've named as your agent. It's a medical decision either by a doctor or a judge. For any power of attorney to be valid, it has to be signed and might have to be notarized depending on what your state's requirements are. It will end as soon as someone passes away, so your agent won't have authority over your financial affairs. If you have a will after you pass away, then your will takes effect. It might also be helpful to check with your bank about whether they have their own forms they want filled out. Even though they have to honor your power of attorney, it can make it easier for everyone involved if the bank's own forms are also filled out. So let's break it down. The two types, or rather the two most common types of power of attorney for financial affairs are what's called durable and springing. If a person wants an agent to start making decisions for them today, and for that agent to continue making decisions for them when they become incapacitated, or if they become incapacitated, they would create a durable power of attorney. A durable power of attorney will start now and stay in effect when a person becomes incapacitated. If someone wants an agent to act only when they are unable to make their own decisions, when they're found to be incapacitated, they would create a springing power of attorney. The way that I think it's helpful to think about it is that the power of attorney that's a springing power of attorney springs into action if a person becomes incapacitated, but otherwise it doesn't. Whether or not someone is incapacitated, as I said, just a reminder, is determined by a doctor or judge, and that person they choose to be their agent doesn't get to start making decisions for them until they are determined to be incapacitated. And quite frankly, with the springing power of attorney, somebody may never become incapacitated throughout their life. So that power of attorney would not come into effect. All right, let's talk about medical records access. So the privacy rule, a federal law under the Health Insurance Portability and Accountability Act, or HIPAA, now you probably know why we just call it HIPAA, it's a long name, gives individuals rights over protected health information and sets rules and limits on who can look at and receive health information. Therefore, written permission is needed for a caregiver who is not a parent or guardian to access medical records. However, if a caregiver is the patient's healthcare agent or power of attorney, then they will have access. Tip number 4. Wow, we're really making great progress, and we're already getting to a crucial part of the presentation. Understand liability for medical debt and research eligibility for benefit programs. So this is a really important tip, and we're going to break it down. So when someone dies, their estate is responsible for paying off their debt. If an estate goes through probate to establish the legal validity of a will, a designated administrator or executor will look at assets and debts guided by law to determine in what order bills should be paid. There are a few situations in which someone else may be responsible for medical debt should a person pass away. If someone shares a joint account with a family member or business partner, creditors may be able to access that account to cover the balance on a debt. Most, but not all states apply the doctrine of necessaries, wherein a husband or wife could be held responsible for the purchase of essential goods and services, including food, clothing, shelter, and medical and legal expenses. A spouse could be liable for the other spouse's debts and contracts regardless of their consent or knowledge of the purchase. Creditors could therefore sue either spouse to recover debts on necessary goods and services, but generally debts incurred before marriage by a spouse do not become the responsibility of the other spouse. Adult children and other non-spouse caregivers are not responsible for the medical debts of their parents or the person with cancer unless they've specifically signed something agreeing to pay or be held liable if the person with cancer could not pay. Some states have laws that make spouses liable for marital debts. Many states are community property. Many states are community property states where certain assets and debts are shared equally in the marriage. Other states have similar laws that require the sharing of debts. It is important to speak with an attorney in your state to understand these requirements. Now, I'd like to briefly go over Social Security survivors benefits. Social Security makes payments to family members of people who are eligible for Social Security benefits, but they have passed away. And I just want to make this point that we cover so much ground in these webinars. And this might be something that does not apply to you, but it is really helpful to just have a general familiarity so that if one day this were to apply, you know where to look, you know that you would have potential rights, and then you already feel that you have these protections out there, and then you can start to either talk to an attorney, contact the CLRC, or just figure out, who might be the next step that you could talk to. But if you at least know that this landscape is out there, then you are more prepared and empowered to make the best decisions to protect yourself and to know your rights. If a person becomes incapacitated but is still alive, a caregiver may also potentially become the representative payee if the patient is still receiving Social Security benefits. To be eligible for Social Security retirement benefits, a person must have worked and paid into Social Security. Certain family members may be eligible to receive monthly benefits, including a widow or widower age 60 or older, or age 50 or older if disabled. Many jobs, such as teachers, have separate retirement and disability funds that may take the place of Social Security. If someone passes away, contact Social Security or a legal aid that lists Social Security or government benefits as a practice area as soon as you can to make sure the family of the deceased gets all the benefits that they are entitled to. Tip number 5, research for assistance and resources to make things more manageable. So we are already in the home stretch of this presentation. You can feel so proud of yourself that you've already covered so much ground and that you've already done so much to learn more about caregiver resources. If you are someone affected by cancer directly and you have someone that wants to be a caregiver, you can have them listen to this presentation, and then they also know their protections. If you are a caregiver or a potential caregiver listening to this presentation, now you know a little bit more about rights. You also know about what are some things that you might be able to help someone with cancer that may need that assistance. Sometimes someone who is a caregiver asks the person with cancer, how can I help? But quite frankly, the person with cancer has so much on their mind, they may not exactly know what they need and what the person might feel comfortable helping them with. So just knowing there's different tasks that someone might need help with, whether it's helping them with a doctor's appointment, helping them get to a doctor's appointment, helping them with a doctor's appointment, reviewing medical records with them, or seeking medical records, researching assistance resources. These are all specific ways that you could volunteer to help. The person may decide that they want your help. They may decide that they might want your help in the future. But it is really important to be aware of this. Also, we want to focus on the fact that being a caregiver is a daunting task. Even if you are not a sole or primary caregiver, we all know that caregiving can take its toll. There are some resources that exist to make the tasks involved in caregiving more manageable. There are nonprofits that exist that help caregivers communicate with friends and family to get help taking a patient to medical appointments or coordinate food drop-offs. There are websites that allow people to do fundraising campaigns for important medical, rent, or other costs, and those websites are such as GoFundMe or others. Additionally, it may be helpful to seek out support groups, counseling services, and message boards to connect with others and learn about things that have worked for other caregivers. It's important to remember that being a caregiver means also remembering to care for yourself. Self-care involves things such as making sure you go to regular doctor's appointments, eat healthy, exercise, and take breaks that allow you to do things that you enjoy. These needs aren't selfish. They help you become a better caregiver for the people that you care about. And I'm not saying that it involves a fancy vacation. It could be just, even if you're being a caregiver for someone, it could be taking a walk around the block. It could be just pausing for a moment and relaxing for just 2 minutes and breathing. It could be just something small to remember that you also take care of yourself. You're better able to physically, mentally, and emotionally be there for someone that you're helping. Next, I want to talk about accessing professional caregiving assistance. Many state or local health departments have licensed home care agencies. Services can include visits by nurses or social workers, medicine delivery, and help with daily tasks. Clients can pay privately or through private insurance coverage. These agencies may also contract to provide services to patients on Medicare and Medicaid. Private long term care insurance may also cover some home care. Ask the insurance agent or caseworker to explain benefits and conditions, or read over the person with cancer's policy to understand whether they have coverage. I would definitely, for this tip, say you can think of different situations and ask the caseworker or the insurance agent, does it apply here? Also, make sure to read over the policy, which can sometimes feel very confusing, but ultimately, it could be a long policy, but if it doesn't cover what is actually needed, then it's not really as helpful as you need it to be. Some states have consumer patient directed programs, which would pay a family member or friend in certain circumstances. Strict rules and waiting lists may apply. Contact your local Medicaid office or the National Resource Center for Participant Directed Services. Another option is hiring a private professional or friend. Formal care contracts may set up a payment arrangement between a patient and a caregiver. It's important to consult a lawyer if possible to make sure the contract meets tax requirements and, if necessary, Medicaid requirements, and that the interested parties have approved the contract. Check to see if a household insurance, like renters or homeowners insurance, covers household employees in case of an accident. If hiring a friend, do not forget to consider the potentially serious emotional pitfalls that can occur when transitioning to an employment relationship from a friendship. Palliative care is medical care focused on improving the quality of life for people with serious illnesses. So it's not just for end of life care. It's a common misconception. Palliative care plays an important role throughout a serious or chronic illness. They don't necessarily have to be for terminal illnesses. The goal for the palliative care team is to focus on the quality of life of the patient, to help people live well and achieve quality life as they define it. What that means is that the team tries to make the person comfortable by treating or easing their symptoms from illness, not specifically curing the underlying disease, which can be conducted by the oncology team at the same time. Palliative care includes pain symptom management, communication and coordination services, emotional and spiritual support, diet and nutritional information, and family and caregiver support. Sometimes doctors will tell patients that they aren't ready for palliative care, but a patient does not need to have to be dying to be eligible or for the care to be appropriate. So it's still important to ask for the referral if there are symptoms that the patient would like to have managed better. And if your doctor or hospital insurance network does not have palliative care doctors to refer you to, you may want to consider seeking additional treatment elsewhere or asking for an out of network referral. Most insurance plans, including Medicare and Medicaid, cover all or part of palliative care treatment, just as they would cover other hospital and medical care services. For example, if a patient is depressed and needs to see a mental health professional and be prescribed antidepressants, that would generally be considered under any health insurance plan, or rather covered under any health insurance plan. Same with pain medicine, consultations with a nutritionist, etc. This is an important point because sometimes somebody might even fare well or better on their treatment if they have that support. For example, if the patient is experiencing severe nausea, then it might be harder for them to really get the nutrition that they need. So if that can be safely managed, and of course that's from the doctor, then it can be very helpful and go a long way to feeling better overall. So it's important to discuss side effects, symptoms with your doctor, and they may change. In the beginning, there might be certain side effects and they go away, or then the the person with cancer may have very mild side effects, but then over time, the side effects worsen. So it's very important to communicate with your doctor, the medical team, and there might be additional care that can really help alleviate those symptoms and make the treatment a lot more manageable and sustainable. Now, I'd like to talk about hospice care. Although palliative care is not the same as hospice, palliative care is an integral part of hospice services. Hospice care requires a terminal diagnosis with less than a 6-month prognosis. 35% of people in the US who are referred to hospice care spend 7 days or less in hospice. This is because people are referred late. The goal is to keep the patient as pain free as possible with loved ones nearby. Most hospice programs offer home hospice services, which is helpful for patients who, like many, prefer to be at home rather than at a hospital. The majority of hospice patients are cared for in their own residence, um, or with a loved one. Although home hospice programs are staffed by nurses, doctors, and other professionals, the main caregiver is a family member or friend who's responsible for around the clock supervision of the patient. The person is with the patient most of the time and is trained to provide much of the hands on care. A family member serves as the primary caregiver and may help make decisions for the terminally ill individual. Members of the hospice staff make regular visits to assess the patient and provide additional care services. Hospice staff is on call 24 hours a day, 7 days a week. Hospice care is covered by Medicare, most Medicaid programs, the Department of Veterans Affairs, and most private insurance. Some limited cost sharing services might be available depending on your health care coverage, such as routine care, inpatient care, continuous care, respite care, medications, equipment and supplies, 24-hour on-call access to hospice staff, and grief support. Home hospice care usually costs less than care in hospitals, nursing homes, or other institutional settings. This is because less high-cost technology is used, and family and friends often provide most of the care. Here are some hospice and palliative care resources that may be helpful. I'll leave this slide up for a minute to jot down a few of these programs. We are the Cancer Legal Resource Center, so of course, no presentation would be complete without providing resources. So the CLRC has many resources available in different states to navigate this process. These are some of our favorite national caregiving resources, but feel free to contact us and we can search for local resources for you. I'll leave this slide up for a minute so you can jot this information down. Well, we have now reached the end of the presentation on caregiver rights. Thank you so much for your attention. If you have general questions about today's presentation or need some clarification, I'll now take time for questions. Thank you so much for participating in this presentation, and I will now be ending this recording.